Hello, everyone. Harry here with an explainer about the Supreme Court draft that leaked yesterday. A lot of very quick off the cuff reaction to it politically, even legally, but I want to describe a little bit what the fuss is about in terms of these actual 98 pages. And they reflect that the opinion was circulated as a draft in February, so a few months ago. You can expect that there are already some dissents deep into preparation, but this is a sort of authentic mark for people who know the court. And indeed, the court confirmed this morning that this is, in fact, an authentic product. This is the very draft that Alito had prepared. All right, so what is going on in that draft itself? So we've got to talk about unenumerated rights, a concept that I think is familiar to many now. And the idea is there are rights that the Constitution protects that are not called out or in so many words in the constitutional text itself. Every single justice, with the possible exception of Thomas, agrees that there are some such rights. How do you know which ones they are? Well, the court has said since basically Roe v. Wade. Some of the opinions predate Roe v. Wade, but Roe v. Wade is kind of the fountainhead decision for conceptualizing what is protected. And it is rights that are very much rooted in the nation's history and tradition. So what does that mean? There are a series of rights, not just abortion, but many that aren't mentioned in the constitutional text. Some very big ticket items like same-sex marriage or the right to marry persons of another race or contraception. Other things such as the right to choose what language your public school child studies and more. And in each of them, the court has recognized rights, even though they're not in the text. And once it has found in the way it currently articulates it, that a right is rooted in the nation's history and tradition, then it said the due process clause of the 14th Amendment protects it. So the basic idea that Alito is doing doctrinally in these 98 pages is singling out abortion and disparaging it, I think it's fair to say, for not having constitutional protection, and for the opinion Roe that originally recognized it being, quote, egregiously wrong. So to do that, and that is to pick up on a phrase of Justice Kavanaugh's. There are different little cookie crumbs in here to attract the votes of especially Kavanaugh and Barrett. So to do that, he needs to analyze abortion as being not rooted in the nation's history and tradition. So how does he do it? And in my view, how does he go awry? He does it by analyzing abortion itself and pointing to legal regulation of it in the 18th century, say, where it was possibly a crime and could be singled out. Of course, that is also true of many rights that we now recognize as beyond any doubt. For example, the right of interracial marriage, the case that established it, Loving versus Virginia, that was a criminal case because it was on the books. And if you ask the question, did the right to marry someone of your not of your race, is it rooted in our nation's history and tradition? If you frame it in that narrow, grudging, pinched way, you're going to come to the answer no. And that is what the opinion does. Whereas when the court in recent years has recognized, say, a right to same-sex marriage, what the court said per Justice Kennedy is, there is a fundamental liberty interest in making, quote, certain personal choices central to individual dignity and autonomy, including intimate choices that define personal identity and beliefs. Now, that is more amorphous, to be sure, but it's also a more principled reading of the precedents that have arisen to date. So what you're going to see in the dissents, what Alito already tries to anticipate, is a fusillade of constitutional rights that are not enumerated, that the court has held is in the nation's history and tradition, but that's because it's analyzed them in a more general and principled way about people's right of autonomy or liberty or to make marriage decisions and the like. It's always going to be the case if you articulate them in the narrowest, most grudging way, that you will find an absence of rooted in the nation's history and tradition. And that's the basic beef, I would say, at the legal crossroads here, much, much bigger at the medical, political, social crossroads. But legally, progressives who want to fight for abortion rights are saying, look, the court has long since gone down this road. There's nothing different about it. Sure, as conservatives will point out, the state, something else is going on when you abort a fetus, that is the ending of a potential life. A state can factor that in, but it doesn't mean there's no constitutional protection or right in the first instance. It just means you have to temper it and give it some ground. And you now, court, you new five, and Justice Alito, you've singled out abortion for disparagement in a way that just doesn't hold up against the rest of the jurisprudence. Of course, part of the super nightmare scenario here is you will hear people saying maybe now the liberal five will go after and put on the chopping block other constitutionally protected rights, such as same-sex marriage or interrace marriage, on the ground that they also aren't in the Constitution. And that would create a sort of tree of an unenumerated rights with every branch stripped away. So that would simply be a constitution that doesn't exist now and would just be, recreated almost out of whole earth, as in a new constitutional convention. All right, so what's going on in legal terms? The five are saying there's something special and different and egregiously wrong about recognizing abortion. And the other side is saying, no, there isn't. It's part and parcel of what we've already done. And the hang up here is partly irrational, perhaps, something to do with abortion itself, or partly because of a misconception of a factor that should matter, but not as to eviscerate the right itself. And that is the potential life that is involved in the abortion decision. All right, so there you have it. Those are the basic way the lines are drawn doctrinally, and the dissents that will be coming out will make very heavy use of the rest of the court's abortion rights jurisprudence to say that these five have irrationally, unfairly, inequitably singled out abortion by an analysis of history and tradition that is different from what the court does in other unenumerated rights cases. There you go. That's my best quick explanation. Much to pour into going forward, but here is the what looks to be coming, and quickly, the law of the land, and why I think it is flawed. That's the explainer of the possible soon-to-be court opinion in Dobbs versus Jackson Women's Health Organization. Harry Litman of Talking Feds signing off.